Good afternoon. I'm Brett Kavanaugh of the U.S. Court of Appeals for the D.C. Circuit. I'm the moderator for the free speech panel on anonymity and the First Amendment. Thank you to the Federalist Society and particularly to Jean Meyer and Leonard Leo for organizing this superb convention. For this panel, we have four excellent speakers. They'll each talk for a few minutes, and then we'll open it up for discussion among the four, and then take questions from the audience as well. Let me first briefly introduce the panelists in the order they will speak. First will be Brad Smith, professor of law at Capital University and one of the nation's leading experts on election law and campaign finance. Professor Smith is a former commissioner of the Federal Election Commission and a frequent author and lecturer on campaign finance and the First Amendment. Lloyd Mayer is a professor at Notre Dame Law School. Professor Meyer's areas of expertise include advocacy by nonprofit organizations and the growing intersection of election law and tax law with respect to lobbying and other political activity. Joel Reidenberg is a professor at Fordham Law School. Professor Reidenberg is a leading scholar and author on information technology and privacy issues. Randolph has been a judge on the U.S. Court of Appeals for the D.C. Circuit for 20 years, and his opinions have had an enormous impact on the law and the country. Before his appointment to the bench, Judge Randolph was, among other things, Deputy Solicitor General at the time of Buckley versus Vallejo in 1976. Judge Randolph is a great colleague, friend, and mentor for me on the D.C. Circuit, and we are honored to have him here today as well. This has been a big year, of course, for free speech and the First Amendment, with the Supreme Court's decision in Citizens United being the main event, of course. And we look forward to our speakers today furthering our understanding of the freedom of speech guaranteed by the Constitution. Professor Smith.
Thank you, Judge Kavanaugh, and thank you all for coming here this afternoon. I am going to focus, of course, on the political dimension, I guess, of anonymity in the First Amendment. I want to point out in opening that the general rule of the First Amendment, which seems to often be overlooked in this backdrop, is that one does not need to identify oneself in order to engage in political speech. Union organizers do not have to identify themselves. That's Thomas v. Collins. The door-to-door salesmen do not have to identify themselves. That's Watchtower Bible and Tract versus Stratton. People organizing boycotts and participating in boycotts and picketing do not have to identify themselves. Talley v. California. Journalistic sources generally are allowed to remain confidential. Generally speaking, membership groups don't have to identify themselves. That's NAACP versus Alabama. At least the members don't have to be identified. In other words, the ability to participate in speech and association without publicly being forced to identify yourself is the norm, the commonplace. Now, there are basically two exceptions to that. One is an exception which is not a public exception by and large, although it may sometimes spill over into the public, but that is an exception for enforcement or investigation. So, for example, you can be compelled, newspapers can be compelled to identify sources. The Fifth Amendment allows somebody to compel a person to identify themselves, a right to face your accuser. You can be compelled to identify information in investigations and so on. But otherwise, other than that enforcement function, the only place in which we routinely seem to allow disclosure is where the First Amendment is supposed to have the greatest bite, and that is in politics. Here, of course, oddly enough, we have a long tradition in this country of anonymous political speech. The Federalist Papers are perhaps the most famous, and they're the one that everybody always points to about the Federalist Papers, you know. But it's not just the Federalist Papers. Of course, at the time of the founding and at the time of adoption of the Constitution and the Bill of Rights, anonymous speech was extremely common. It was participated in also by most of the anti-Federalists. It wasn't just Madison, Hamilton, and Jay. It was Richard Henry Lee and Sam Adams. The great Chief Justice John Marshall wrote anonymously in order to defend his decision in McCulloch v. Maryland. and would have been, I think, very embarrassed and struck had he been required to identify himself. And this remained the norm for many years. Thomas Jefferson, Winfield Scott, Abraham Lincoln, all kinds of great American statesmen routinely used anonymous political speech to further their political objectives. I think that there were many reasons for doing so. They include the desire not to disrupt social relationships, the desire to leave open the ability to compromise politically, to make later compromises in deal-making without having pinned oneself into public positions or without having offended those with whom one had to deal. And they included the prevention, among other things, of harassment. And in that area, of course, we have cases NAACP versus Alabama, Bates versus Little Rock, or more particularly in certain areas, Brown versus Socialist Workers Campaign 74 Committee. So the growth of disclosure is really a relatively new thing, and it seems to me that that is so often lost in this debate. People talk as, well, of course it's disclosure. Of course disclosure is perfectly found. In fact, I know that I have on good source that at least at one point in shooting down a person who was concerned about new disclosure requirements coming out of Congress for grassroots advocacy, a member of Congress, prominent member at the time, said, I don't know why you're concerned. It's not regulation, it's only disclosure. Okay, well, try not filing your disclosure reports and see what happens, and then you'll might know. Now, there are three basic arguments that have been made in favor of disclosure here. One is that disclosure is necessary to help with enforcement. This argument to me doesn't seem to hold much water because that doesn't require public disclosure of speakers. If, for example, in the political realm, the government needs to know who is speaking so that it can enforce limitations on contributions and so on, just as the IRS doesn't disclose the contents of your tax returns or many other things, the government can investigate or could require some type of filing so that it could carry out that function without requiring public disclosure of the information. A second element is the idea that it's needed to help the public prevent corruption. They can kind of police their office holders if they see who's giving to the campaigns. Well, I think that's a weak argument, in part because the social science data simply doesn't show that campaign contributions are really that important to what office holders do. They're usually not a source of corruption. If somebody's really corrupt, like Duke Cunningham or Bob Ney or William Jefferson, they just take bribes and put it in their refrigerator or gamble with it. They don't care about the campaign contributions that are made. Moreover, that would not go very far in the push for disclosure of independent spending, spending that is done independently of candidates. And ultimately, I think that rationale really collapses into the third rationale, which is that disclosure is needed to provide cues to voters so that those voters understand, know what they're getting into, know who they're voting for. They know how to evaluate a message. Now, I think here that there are a number of issues that go with this. First is that disclosure in this respect is not always helpful. It can be misleading. For example, if home builder Bob Perry, legendary funder of Swift Voters for Truth, Swift Vets for Truth, and so on, gives a large sum to the National Rifle Association, and then we require the Rifle Association to report that he gave them a large sum, and this has to be put into advertisements, which has now been proposed when the National Rifle Association endorses, say, Ted Strickland, the Democrat for governor of Ohio. People are not going to be particularly enlightened. They're going to be confused. Wait, Bob Perry, Republican, is endorsing Ted Strickland, Democrat, for governor of Ohio? No, the National Rifle Association is, and Bob Perry may give money to the National Rifle Association. But I don't know if he does. That's just a hypothetical type of situation there. It also can be, of course, very detrimental to political debate. It can encourage people simply to attack the speaker rather than to discuss the ideas that are involved. And so I'm not sure how great of a cue it often is, and moreover, the cue is typically there at the very first level of disclosure at a minimum, which we have in most political advertising. For example, if the Chamber of Commerce says it supports something, do we really need to know who gives to the Chamber of Commerce. Remember when some of this disclosure first took place in 2000, we learned that the Sierra Club was supported in part by a guy named William Hambrecht, who's a big-time banker out in California and a long-time donor to all kinds of liberal causes in the Democratic Party, and that was well available to anybody. And I remember sitting around thinking, boy, that's good to know, because I used to think that the Sierra Club was just like an environmental group, but now I discover that they're in cahoots with the Democrats. This was stunning to me, and I immediately quit giving to the Sierra Club. What is overlooked in this, I think, are two other reasons, and in my mind, these are really the reasons for the push currently for disclosure and for more and more endless sort of disclosure. The main one is to harass political opponents. There is a strong effort these days to use the disclosure system, compulsory disclosure, to harass one's opponents and to organize boycotts. We saw that in this campaign in an effort to boycott Target because they gave money to a group which then spent that money supporting a Republican candidate for governor in Minnesota who's viewed as insufficiently pro-gay rights. But it takes many, many forms. For example, a couple years ago, a group called Accountable America sent letters to 10,000 conservative donors around the country threatening, in the words of the New York Times, to dig through their lives, hoping to create a chilling effect that would dry up contributions. And that was very clearly their intention, and it was, of course, Accountable America, headed by a prominent Democratic activist. We have other efforts, such as in Proposition 8 in California, where supporters of that were harassed in many ways. Opponents of the measure used the mandatory disclosure list to obtain information. One restaurant was boycotted, noisily picketed, and so on, because the daughter of the owner had given $100 to the Yes on 8 campaign. In another case, in many cases, people lost jobs, property was defaced, and so on. These kinds of threats are mild compared to what can be out there. For example, there's a group called SHAC, Stop Huntington Animal Cruelty. This is an animal rights group that makes PETA look like a bunch of pikers when it comes to extreme. SHAC is designated as a terrorist organization by the FBI. Its members have, in fact, beat up executives from Huntington Animal Labs outside of their homes with baseball bats, right? Now, Stop Huntington Animal Labs used information gathered from the mandatory disclosure reports on the internet, available to anybody who wants to see them, to put a list on the internet of people who worked for companies that did business with Huntington Animal Labs. And they found these people and they put their names on the internet under the heading, "Now you know where to find them," with their home addresses. So this is not trivial type stuff, and it's not just hypotheticals that we're dealing with. I think that, how much time have I got, Judge? Am I over yet? I've got
a couple minutes.
Couple minutes. Okay, well, I only need about 17, so if we can swing through 17 more minutes. Thus, I would simply suggest, in the Proposition 8 case, by the way, one activist said years ago we would never have been able to boycott or to get together a boycott list so quickly. So this apparently is progress since the McCarthy era. Now, the thing about all this, of course, is that retaliation can also be official. What was the K Street Project? It was about, at least in the minds of Democrats, an effort to set up an official retaliation system against Democrats. According to the Wall Street Journal, in 2007, the Journal quoted a Democratic political strategist as saying, quote, "If you have an issue on trade, taxes, or regulation, you'd better not," I'm sorry, they got to read my own writing here. "You'd better not be a donor, and you'd better not be part of an effort to fund ads against our freshman incumbents." So retaliation is not just informal, but it's official. Now, normally, this is the First Amendment, and we would require a compelling government interest before requiring this kind of disclosure. But there seems to be a tendency often in the courts to apply some lower standard, and I do not believe that it is a compelling government interest in making it easier for private citizens to boycott other citizens in the area. So there is another reason behind disclosure, but given my yellow light warning, I will leave it at that. And what I will say is simply this. Justice Scalia in particular has expressed the desire or the feeling that anonymous speech is nasty speech. But I think that the First Amendment equation, which was long recognized in this country right up until the last 20 or 30 years here in the political realm, is that anonymous speech maybe actually is less nasty speech. Thank you.
Well, Brad's done a great job at setting up the issues here, so I'm going to essentially pick up where he's left off and talking about the two things that he focused on, the retaliation, and on the other hand, this issue of whether we actually learn anything useful from disclosure. By we, I mean as voters, as citizens, choosing candidates when we go to the ballot box. And I think this debate is complicated by the fact that when you read Supreme Court decisions area, most particularly the Citizens United very brief discussion of disclosure, but also Doe versus Reed most recently, there is not a lot of thought given, and maybe this is a failure of briefing more than a failure on the court's part, with respect to, well, really how do voters learn about candidates and what do they do with that information on one hand, and on the other hand, as Brad has pointed out, what do we really know about retaliation? When does it happen? When do these disclosures really expose people to retaliation and chill people's speech? And what I'd like to contribute here, hopefully, is to add a little more information on both those grounds. With respect to informing voters, at only a moment's thought, you can realize that simply having more information is not necessarily useful. You only have to look at the Bing ads, right, about Google to realize more information may not be particularly helpful. What matters is what information you receive and how you receive it. And this is where I think Brad's got a very good point. Most of the information we learn about in terms of donors is about rank and file donors. And frankly, it doesn't tell us very much. Why? Because we don't know anything about these people. Even in the McIntyre case, the handbill case where the Supreme Court upheld the anonymity of Mrs. McIntyre and her requirement that she not have to put her name onto the flyer that she was handing out, it said, essentially, who knows who the heck Mrs. McIntyre is? You don't learn anything if you get a handbill by having her name and address on it because no one knows who she is. And that's true for the vast majority of rank and file donors. It really doesn't tell us much to know that, for example, I gave money to somebody because none of you knew me before I got up here, right? It doesn't really tell you much about the candidate. And so I think that's exactly right, that the informing voter importance of that has been overemphasized. But it's also true, and this is why I would depart from Brad, that in some situations we do learn things by knowing who's financially supporting, for example, independent ads relating to candidates. And yes, it's true. If it's the Sierra Club or the NRA, all you need to know is Sierra Club or NRA, right? You've got a pretty good sense of where the candidate probably stands. But if it's Americans for America, for example, what does that tell you? That tells you nothing. Right? And this is, of course, the complaint that's been happening in recent years. Now, that doesn't mean you need to know every donor who gave to Americans for America. No, you don't, because, again, most of them you won't know. But it does argue that at least the largest financial donors, particularly when, as we've seen in the past, and a classic example of this, Republicans for Clean Air back in 2000, you have a group that turns out to be funded by 2 or 3 people with a particular political agenda, which is easy to discover once you know who they are. And so their disclosure does serve a voter information purpose, and a very important one. They may say, well, as Brad said, you should have to judge the message by the message. The messenger shouldn't matter. But of course, that's not how we function. Because you watch TV in the past couple of weeks, you saw a lot of political ads, right? At least I did in the Indiana District 2, which is a competitive district. You're not going to sit there and parse through every ad, do the fact-checking for every ad, even the most intelligent and involved person. You're going to use cues, and one of the cues is who paid for this. And if I know something about who paid for it, that's going to allow me to interpret that message, and very quickly, without having to do all the research. Is it perfect? No. Will there be mistakes? No. Does it always work? No. But it does provide some useful information at that high financial support level. Well, again, high financial support, often the person's going to be recognizable, identifiable in the political stances in some way or another. There's also the question, and this alludes to it, of how you receive that information. Having the information available in an FEC database, even in the age of the internet, isn't particularly helpful. Because how many of you went to the FEC database before the election to search for who was donating to particular candidates to decide who to vote for? Okay, we got two real wonks here who did that. Okay, people don't do that. What do? You go to Fundrace on Huffington Post after the election to find out who your neighbors and coworkers gave to, right? That's what you do. And that's not the informational interest we're interested in serving here. I mean, it's interesting, right? It feels a little bit unseemly, but it's interesting. But that's not the informational interest we want to serve here. And so again, exposing the rank and file donors to that kind of disclosure is wrong, and delivering that information only by going to the FEC database or to Fundrace or to the Proposition 8 websites that were set up after the election, or to retaliate or expose or at least just learn about what people are doing, is not really furthering that informational interest. Which is why I think acknowledging who supports ads or publications is where the key is. The name that appears at the end makes a difference. And if the name is not the Sierra Club, the NRA, or some group you recognize, the names of who supported that group makes a difference, and in terms of interpreting that message, and that's where the delivery should occur. Now, I'd be remiss if I didn't address Brad's retaliation point, because, of course, that is the key downside of going against what I think he's right, the default choice should be, which is anonymity. And this, of course, is the point that Justice Thomas made in his dissent on disclosure in Citizens United. The problem with the retaliation narrative is once you start looking at the actual cases, they're relatively isolated. The NAACP case, well, we all know the history of the civil rights movement and what were transparent attempts to expose the dues-paying members and financial supporters of the NAACP in an attempt with a blatant retaliation agenda in that case. The Brown versus Socialist Workers Party. Socialist Workers Party clearly has a history of being discriminated against, not just by private individuals, but by governments. In fact, they just recently got their exemption from disclosure renewed because they were able to demonstrate, even in this decade, that they've had a history of retaliation against their identified supporters. Accountable America is interesting because they did send out 10,000 letters, and the response of all the conservative donors, at least talked to reporters, was, who cares? Who cares? People know what my stances are. I'm not going to back down. And they never went public with the massive database they were going to do and the boycotts and all this other stuff. It turned out to be, in many ways, a bluff. Now, the Proposition 8 stories are real. The retaliation stories certainly are credible. But a couple of things are important. If you pour through the exhibits in the litigation about the retaliation, first thing is many of those people, their positions were known not because of their donations to which were disclosed, but because they had bumper stickers on their cars, or they had signs in their yards. So they were not hiding their support, and they weren't outed in some way, no pun intended. They were not outed in some way by going through the disclosure regime. Now, a few were. There certainly were credible stories of people whose support only came out through the disclosure regime. But again, this is the rank and file donors. These are the people that knowing that they gave money really isn't particularly helpful. So I would send to support, and I would change the disclosure regime that is simply more targeted based on the research we have. So the first thing is there's no need to have the rank and file donors' names and addresses out there. It doesn't have to be publicly disclosed. Maybe it should be disclosed to government for enforcement purposes. Maybe it should be disclosed for the government, just the government, for aggregation purposes. Because you might want to know, hey, is my candidate in my congressional district being supported by a lot of donations from out of state? You don't care who the individuals are, but you might want to know if they're being supported from out of state, or mostly in-state, or from trial lawyers, or insurance executives, or pick your particular group that you think would be helpful to know. But you don't need to know the individual names and addresses, which is what exposes people to retaliation. It's only, especially in the area of the independent ads, I think, that you need to know who's actually paying for these ads at the large dollar levels. And then I think, as I already mentioned, the way you deliver the information is key, and it has to be delivered in connection with the messages that are coming forward. So again, this doesn't reach the contributions of the candidates, where some of these other interests kick in. With the independent ads, the information that you need about who's supporting them needs to come in the form of the donors. There's a professor at Loyola Los Angeles, Justin Levitt, who's proposed sort of the equivalent of the nutrition label on the ads. So instead of having a nutrition label with how many calories and fat and so forth, you have, paid for by whatever group, 5 largest donors, percentage of small donors, something like that. I'm not saying his idea is necessarily the right one, but that's a useful thing because, when you're sitting there watching the ad or see the newspaper ad and whatever, there's a little box. Certainly, it's more useful to have nutrition information on the cereal box than it is to have it on the FDA website, and the same thing works with ads. I'll leave it there. Thank you.
Thank you. I'm delighted to join you this afternoon. This is the first time I've had the opportunity to come to one of these events, so it's a real pleasure. I am not a First Amendment scholar. I write in the privacy law area, so I'm going to address more the anonymity side of the anonymity and First Amendment issues for today. And I'm going to set it in a particular context. We heard Brad Smith talk about the value in democracy to having anonymous citizens or non-transparent citizens. The flip side to that is we also have a very deep value in having a transparent government, or rather a non-anonymous government. And in the case that came down this year that I'm going to focus on, the Doe versus Reed case, I think we see these two issues, the non-anonymous government value and the anonymous citizen value coming into play and into potential conflict with each other. When we think about some of the instances in the electoral process, how is it that we have transparency in government? What do we want? We want public oversight. We want some public transparent mechanism to know that the electoral process is fair, to know that it's playing out the way it's supposed to be playing out. So should, for example, in the Doe versus Reed context, should the Secretary of State be able to act in secret? And that's what the disclosure of petition names really is affecting. If we think about the petition names in that case, those names were already public. It wasn't the FOIA law that, in fact, was making them public. Why do I say that? Think about how you sign up for a petition. Either someone's going door to door, so you're confronting someone who oftentimes you don't know. You're making a public act, deciding to sign the petition. You sign a petition on a street corner. If you sign the petition in the privacy of your home, in bed, all cozy, nice and cozy in bed with your computer on your knees, that too is in fact public in many ways. Why? There are a myriad of intermediaries that gain access to the information that you're providing when you sign that petition. There's nothing in signing the petition that suggests that the organization collecting the signatures won't, in and of itself, make it public, disclose it. So it isn't simply the state actor that is disclosing this information. There's an action that's taking place in public. The petitioners are making requests to government. They're engaging with the government, in the governance process. And I think that's a very strong argument in saying this type of action in our society, if we want a transparent government, that should be transparent too. So what's the problem? The problem is really, and I'll come to it was phrased as retaliation. The problem from a privacy point of view is something different. It's secondary use. It's secondary use of that personal information. And that's where the retaliation comes into play. So if the data is disclosed, the petitioners are disclosed for the purpose of having a transparent electoral process, knowing that the Secretary of State's office is properly functioning, that's the proper first order use of that information. It's the second order use, the secondary use that's the problem. If there's harassment, if that data is used not even for harassment, another quite common use of the electoral information that's made public is for profiling to sell you soap, for commercial ad profiling. Those are the areas that we're now confronted with addressing. And I would argue that we should be addressing those indirect burdens of disclosure separately and address those head on. If the problem is harassment, then sanction quite powerfully harassment. Define what harassment is and sanction that. Don't shut off the first order valid reasons for making information public. I think I probably have another minute or two. So So let me conclude with a couple of words about campaign finance and disclosure. I'll leave to the others more on the Citizens United case. But we are seeing some interesting things. I guess I part company with the notion that disclosing information about donations by rank and file really doesn't have much meaning. Because what we find today is data mining and pattern recognition, in fact, can provide quite substantial meaning to individuals' activities and activities of individuals as such. And again, in that context as well, my concern is what's the secondary use of the information? If it's used in the context of legitimate, valid political process, that's why it should be known. If it's used for other things that as a society we deem are not valid, like boycotting stores, if we say that's improper harassment, then let's come up with a way of sanctioning that harmful secondary effect. In the corporate context, as a privacy scholar, I have grave questions whether corporations should have privacy rights. We think about privacy, we think about it as a citizen's right, as an individual's right. It is the right of the citizen. The legal entity, it's far more troubling, I think, to ascribe to the legal entity the same notions of privacy that we ascribe to individuals. So I'll conclude with that. Thank you.
Very tight quarters here. You have to be careful, particularly when you're old like me. I thank my colleague Judge Kavanaugh for that introduction, and I was involved with the Buckley versus Vallejo case, and I was deputy, and I had a young assistant who gave me a draft, which was magnificent. I rewrote part of it and added some things. His name was Frank Easterbrook, and then our editor was Robert Bork, and so the three of us put together the Attorney General's brief in that case. I'm going to talk about Citizens United, but I just want to start by saying, it's been 36 years since the statute in Buckley was adjudicated, and it came in the wake of the scandals during the Nixon administration, and in honor of which I'm wearing a pair of cufflinks that Richard Nixon gave me. I represented him after he left office, but anyway, there was a fellow named Herbert Kalmbach who went around to various corporations with a briefcase, and when he left after meeting with the CEOs, he had a briefcase full of cash. That money was used in part to fund the legal defense of the Watergate burglars. And that led to the amendments to the Federal Election Act and the ultimate Citizens United because of the later iteration in McCain-Feingold. Well, anyway, the Supreme Court decided the Citizens United case almost a year ago, I think 9 months, 10 months, something like that. And what has happened is there's been an enormous amount of commentary about it, and I think an enormous amount of misinformation about the case. And I want to pick out 3 myths from Citizens United, the last of which deals with anonymous speech, but I want to work up to it. And let me give you a little bit of background about the case. In January of 2008, there was an organization, Citizens United. They released the movie. The movie was called Hillary the Movie. I've seen it. It was terrible. It was a bunch of talking heads. All our friends were interviewed and talking about Hillary. But anyway, the company, Citizens United was a corporation, wanted to advertise the movie and then wanted to make it available through cable TV, video on demand, and I think satellite as well. But the problem was the McCain-Feingold Act passed in 2002 prohibited something called, a new term, electioneering communications. Within 30 days of a primary election, 60 days of a general election. And this new category, electioneering communications, what it meant was communications by other than a media corporation, communications over broadcast cable TV or over satellite that referred to a candidate for federal office, and then because of a modification in another case, what I won't go into, and engaged in what we call express advocacy, or the functional equivalent of it. The Citizens United case came up from our court. Actually, the district court. It was what they call a three-judge district court. I was the circuit judge, and we had 2 district judges. And we issued an opinion. By the way, judges engage in anonymous speech all the time. It's not widely appreciated, but we call it per curiam. So Citizens United was issued per curiam. Nobody knows who wrote it. I wrote it. I confess. And had to basically hold my nose over certain things, but because of the McConnell case had tied us up, and the Supreme Court transformed the case, and so on and so forth. But one of the issues, the way it was argued to us, was that Hillary the movie wasn't really express advocacy. It wasn't advocating the defeat of, certainly wasn't advocating the election of Hillary Clinton, but it wasn't advocating, the attorney argued before us, he said, wasn't advocating the defeat. That was not the message. So I asked him during the oral argument, I said, what was the message? And he said that Hillary Clinton was a European socialist. I said, oh, that has nothing to do with her election. But anyway, this brings me to the first myth, which is that Citizens United, quote, reversed a century of law. Now, when the president said that during the State of the Union message, he must have had in mind a statute that was about a century old, the Tillman Act of 1907. That statute prohibited corporations from making campaign contributions to candidates. But Citizens United didn't have anything to do with that. We're talking about independent expenditures. A law prohibiting corporations and labor unions from making independent expenditures did appear for the first time in the Taft-Hartley Act of 1947, but for the next 30 years, the Supreme Court just avoided dealing with the constitutionality. One way or another, they avoided it. And then came Buckley versus Vallejo in 1976, and the court held that restrictions on independent expenditures by individuals and by corporations were unconstitutional. And so, nevertheless, the McCain-Feingold Act passed the electioneering communication, and despite Buckley. And so, it was the McCain-Feingold Act after Buckley in 1976 that upset settled law. And one might say that by no measure did the Citizens United reverse a century law. The accurate way of putting it, and dispel the myth, is that McCain-Feingold, not Citizens United, upset settled law, and in other words, Citizens United merely restored the status quo ante. And that's all it did. The second myth is that the Supreme Court broke new ground, and I've read this in blogs and so on and so forth endlessly, by recognizing the First Amendment rights of corporations. And sometimes it's put more broadly. It says corporations are creatures of the state. They don't have any constitutional rights. So in other words, I guess the state can go out and take their property without due process or without having to pay just compensation or do a bunch of other things. But this, and this charge doesn't appear very frequently in the press, and you know why, that corporations don't have any First Amendment rights. Why is it? You know, the New York Times wouldn't say that. And the Washington Post wouldn't say it, and ABC wouldn't say it, and all the other, and Fox or any of the others. And the fact is, I did a count in reading Citizens United, and by my count, I counted, just cited in the opinion, 23 Supreme Court cases recognizing that corporations have First Amendment rights. I'm sure there are others, but I haven't done the research. 23. Of course they do. As some of the commentators, by the way, suggest that, well, that's different. It's media. Media corporations have first, after all, the First Amendment says freedom of speech and of the press. But the fact of the matter is, in Supreme Court history, the Supreme Court has never, ever given the press greater free speech rights than anybody else. And the prime case that it illustrates is New York Times versus Sullivan, because the ad that was placed in the New York Times that led to the libel per se action down in Alabama was an ad placed by individuals. Heed their rising voices. That was the ad. It was placed by individuals, and when the suit came, it was against the New York Times and the individuals. And the Supreme Court, in an opinion by Justice Brennan, drew absolutely no distinction between the two. And it's besides that, it's difficult. How do you define who's the press anymore? I mean, the people. Am I the press if I get on a blog? I think so. Maybe, I don't know. But I don't have any greater rights than anybody else. And now for the third myth, which is closer to home on the subject here. In one of his, I don't mean to pick on President Obama, but here goes. In one of his weekly addresses during the campaign season this fall, he claimed that this is that Saturday chat that they have, and I'm going to quote this exactly. He claimed, "Citizens United gave special interests the power to spend without public disclosure." Supreme Court opinion gave public interests the power to spend without disclosure. And the Washington Post had a bunch of editorials, and there Eugene Robinson had an article. And the Post, one of the editorials that I clipped out was entitled "Stealth Money." And it railed against ads, quote, "savaging candidates." And this was the fault of the Supreme Court because the court, quote, "didn't require the folks picking up the tab to stand behind their words." And the New York Times did the same. And if you'd listen to this, you would think that the Supreme Court upheld corporations engaging in express advocacy and hiding who they really were. That's not true. The Supreme Court opinion, go look at it, upheld the disclosure requirements of the McCain-Feingold Act. That was an issue before us. It was an issue before the Supreme Court. They lost before us, and they lost before the Supreme Court. And the Supreme Court also upheld what they call the disclaimer, which is when you place the ad, you have to put in the ad itself the source. You know, I'm George Bush, and I approve this ad, or whatever. So the fact of the matter is that the charges by the press and so on that now we have stealth money and so on are not correct if they're laid at the feet of the Supreme Court. The place to complain about is not there, it's the Federal Election Commission. It was the Federal Election Commission that carved out a special exemption, relieving corporations of some disclosure, but not relieving them of this disclaimer putting the material in the ad. Well, I'm going to, am I out of time? I'm okay? Okay. Well, I can go on then, I guess. But anyway, so the question, I suppose, is where does this leave anonymous speech? You have the Supreme Court of the United States upholding, once again, for the second time, the restrictions in McCain-Feingold. And the Supreme Court did that, by the way, despite the fact that our per curiam opinion teed up an issue. The issue was that the Supreme Court, in a series of at least 4 cases, the McIntyre case, the Talley case, and I'm not going to go through them all, but the city of Stratton, had indicated or held that there was a right to anonymous speech. You can go into a town, and you don't have to stop at the town manager's door and tell who you are. The Supreme Court held that. You can distribute campaign literature, and you don't have to put on the campaign literature the source of it, or your name, or anything else, and so on. Well, those cases, in the McConnell case upholding disclosure under the McCain-Feingold Act, the Supreme Court never distinguished those cases. In fact, it mentioned one of them, but only in a footnote on something else. It never attempted to square a line of cases upholding an anonymous speech with suddenly the disclosure requirements of McCain-Feingold. And so we dropped a footnote in our opinion, and the footnote referred to an opinion by Frank Easterbrook in a case called Majors versus Abel, I think it was, or Abel versus Majors, a case from Indiana. And Frank Easterbrook refused to vote in the case. The opinion was by Judge Posner, but Judge Easterbrook's opinion reads dubitante. And he said, I don't know where the principle is. How can I vote? The Supreme Court says one thing in McConnell, and it says another thing in these other cases, and it gives the lower courts absolutely no principle to apply. And I think that's where we are right now in terms of anonymous speech. I'm going to wrap it up by saying simply that I think we're sure there's no general right to anonymous speech, and I guess we can cite McConnell and we can cite Citizens United for that proposition. But there is, in some areas, because the Supreme Court's recognized it, a particular right to anonymous speech. The question is, how do you determine which is which? On which side of the First Amendment you fall, protection or non-protection? And the problem is that, at least in my opinion, and Judge Easterbrook's and a number of other people, is that I can't tweak out a principle that will enable me to make that decision if I am faced with a case like the case that faced the Seventh Circuit in Majors versus Abel. And I'll stop. Okay.
I think we'll ask the panelists to follow up with any comments they have on what they've heard from the others, and then we can start taking questions as well. I'll start with Professor Smith with a question I have. Why is it, do you think, that the Supreme Court in this area, Supreme Court that's been very protective of free speech in a lot of different areas, and including Justices Kennedy and Scalia, very protective of free speech, why is it that in this area, in your opinion, are they not seeing it the way you think they should?
I suspect there are a couple of reasons. One is, I think, for reasons that Lloyd and Joel have stated. I mean, there is value or perceived value by many people in having this disclosure. And I note, again, and this was sort of implied in my comments, but it should be clear, what we're really talking about, at least the present debate in politics, is second-order disclosure. In other words, this has been made clear. Every political ad tells you who's paying for it. It's just people often want to know more. They want to know more than it's just the Chamber of Commerce, or perhaps with more justification, they want to know more than it's just Americans for American things. And so there's always the disclosure of who's paying for it, but they want to know more than that. I think the court sees some advantage there, and I'm not sure that there's not advantage there. Again, I just go back to kind of traditional analysis. Is it truly a compelling government interest? And I also look at it as a question of, is the First Amendment here merely an advisory scheme as to what we want, and we should sort of defer to the legislature and let them decide the various merits of compelled disclosure versus allowing anonymity, both of which I think there are strong arguments for? Or do we view the First Amendment as in fact a considered policy choice by the founders that wrote this into the Constitution, that this is the one we think's the best, so much so we're putting it in the Constitution? I think too often we neglect constitutional language for constitutional values. You know, I always envision them sitting around in 1790, you know, and kind of go, well, we promised to write in these amendments, you know, and, well, how about something about speech? Well, how about Congress should make no speech? Well, no, we don't really want that. I mean, obviously, they're going to make some rules against speech. And then somebody else says, no, we want no rules against speech, none whatsoever. Really? None, you know? Well, okay, well, how about if we write, okay, how about Congress shall make no law? Will that do it? Okay, yeah, that'll do it. I mean, you know, we all say, oh, well, it doesn't really mean no law. Well, I'm not sure it doesn't mean no law. Now, I'm getting off your question, so I'll try to get back.
That's okay.
I think there are two things. One is, as Judge Randolph said, this comes right after Watergate. And I think the court in Buckley was very reluctant to say, you know, absolutely no regulation in this area. I think courts, maybe the judges here can correct me, but, you know, they operate in a political context too. They read the papers, they see what's going on. Whether they consciously think about it, they're just like the rest of us, and these things have to influence some of their decisions. And then from Buckley, which first begins to allow some of this disclosure, although Buckley's more protective, I think, than some of the later cases, what we have is a case in which those of us who have largely been on my side of this debate about campaign finance generally have cooked our own goose a little bit. For years, you know, you have conservatives and libertarian sorts and just ordinary people like me going around saying, you know, we don't want to limit the size of contributions, but these people always say, you have to declare every expenditure instantly over the internet. And we usually pound our fingers on the table like that to show that we were really serious about corruption. And after a while, people begin to think, it's just disclosure, like the congressman saying, you know, well, this isn't regulation, it's just disclosure. And so I think some of it has been a case in which the way we have framed the debate ourselves has led judges to perhaps overestimate the value and underestimate the cost.
Professor Mayer, question for you. You suggested that disclosure has many positive impacts, but you acknowledge that it would be different if there's a threat of retaliation, I think. How can you assess, however, the threat of retaliation beforehand? How can you be, there's no way, some would say, to guarantee no retaliation beforehand?
I think that's a good question, but in some instances, that has been able to be anticipated. I mean, the Socialist Workers of America case is a good example because they sought an as-applied exception to the disclosure rules and received it from the Supreme Court initially, but for a temporary period. And they actually had to renew that recently, and they were able to bring to the FEC, in this case, evidence that, well, it's true, our supporters aren't being disclosed by having their donations revealed because we've had this exception. Obviously, people do learn about some of our supporters' affiliation with our party, which is disfavored, and we can demonstrate that they, in fact, have been retaliated against as a result. Actually, the same-sex marriage debate is a good example of this as well, because supporters, there are people who are publicly supporting initiatives to repeal same-sex marriage laws or overturn court decisions on this, who have bumper stickers, who have yard signs, and if they are retaliated against because of that, that's evidence to say, well, then don't disclose the Doe versus Reed petitioners. Don't disclose the donors on these issues, because we have evidence that people will go out and they will fire people. They will, burn down their yard signs. They will, smash the windows of their cars or whatever. So there is ability to demonstrate ahead of time. Now, so far, the people haven't been successful in doing this, but there is ability to demonstrate ahead of time that a particular issue or concern is likely to generate the kind of harassment retaliation which we think should not be allowed. And I think this actually feeds into Brad's answer to the first question. He says the court discounts the likelihood of the harm here. And I think that's right, because they haven't had it really proven to them, except for Justice Thomas, who does believe it has been proven. Their view is, I think, that except in limited circumstances, which then we will grant an exception, Socialist Workers' Party and so forth, come to the court, show us that you're one of those limited circumstances, we'll say no disclosure in your case. But we haven't seen enough broad-based harm to say in all cases we're not going to require disclosure. It's interesting that before Proposition 8, I actually looked pretty hard for retaliation cases because I was interested in this issue, and I couldn't find anything. I couldn't find news stories about people getting fired from their jobs or people losing even business or whatever. I'm not saying it didn't happen, but I'm saying it was hard to find those cases, and the case hasn't been made to at least 8 members of the court at this point, I think.
Professor Reidenberg, you suggested that if the problem's harassment, just define it and ban it. How do you define it?
That's a tough question. Well, I would start, certainly anything that's going to be a physical threat or firing, somebody being wrongfully fired, and I would say wrongfully fired is in a job where their political opinion becomes the basis for the firing. Burning lawn signs would be another example. But I don't know that I would go so far as to say economic boycott threats would be at the level of harassment. We had an interesting case, what was it, about 2 years ago, with the Lehman Brothers bankruptcy. And the question came up in a bankruptcy proceeding. Typically, the assets of the debtor are public record information. It's disclosed. So in the Lehman case, you had the debtors, or excuse me, the creditors included senior executives who were owed phenomenal bonuses. And that was to be listed on the on the creditor lists to be filed in the bankruptcy proceeding. And there was a lot of concern whether, by making that public, whether those individuals would be at physical safety risk in their communities. To me, the response is, all right, if they're at physical safety risk, that's the police's job in the community. If anyone is physically threatening them, arrest them and sanction them, send them to jail. But to say that, the other side, where I said the economic threat, to say that if an individual doesn't want to do business with an organization that it thinks is acting repugnantly, that individual ought to be free to make that decision. And it cuts both ways. So I guess I would start by drawing the line with the physical wrongful termination, things like that.
I'd invite people to start lining up for questions. I'm going to ask one to Judge Randolph, but if people want to start lining up for questions, that would be great. For Judge Randolph, your experience in the Buckley versus Vallejo case is fascinating, I think, and obviously the court ultimately drew a distinction upholding the laws that banned, that limited contributions, but striking down the law to the extent it limited expenditures. Did you, or did anyone see that distinction coming at the time the case was being argued?
No, we didn't. We filed, by the way, I don't know if any of you saw the article on the front page of the New York Times yesterday about the length of Supreme Court opinions. The Buckley versus Vallejo opinions, majority, concurring, et cetera, are the longest opinions in the history of the Supreme Court. So, no, we didn't see that coming. And in fact, the brief that we filed was what we called a true amicus brief. It was gave the arguments on one side and the arguments on the other side without taking a firm position. In the case, I'd like to say that it reminded me when Professor Smith, I think, was saying no law means, the First Amendment, that Congress shall pass no law abridging the freedom of speech or of the press. And Justice Black used to say that all the time. No law means no law. Slam the table. That's not the issue in the First Amendment, the freedom of speech. The question is, what is the freedom of speech? If you look at a regulation, you say that's a law, or you look at a statute, yes, of course it's a law. But does that abridge the freedom of speech? So the question is, what's entailed within the freedom of speech, and what does abridge mean? And I'd like to say one other thing about anonymous speech. It strikes me that there's an argument that out of all the various areas where there should be disclosure and not allow anonymous speech, it should be, you should require disclosure in speech that invites retaliation. Because otherwise what it means is the most vicious attack, the worst thing that somebody says about another person, that if they said it face to face, they get a punch right in the nose, and it would be fighting words, and you would not, it would not be protected by the First Amendment, that those people, that group of people is entitled to do that and attack you anonymously. So that's one of the problems in the definition. Now, I understand the other areas of retaliation is another matter. And I'll end on this note. My memory is that, in fact, and you may know this, there's a federal statute that prohibits wire telephone communications that harass if the individual does not identify themselves. And we had a prosecution, reviewed a prosecution under that federal statute. It might have been, it was years ago, far more than a decade ago, and I think the case was Popo or something. I can look it up. But there, in fact, is a federal statute already, at least, that deals with these kinds of telephone calls, like the mother gets a call in the afternoon, and on the other end of the line, somebody who doesn't identify themselves says, "Your daughter, we're watching her." I don't know, is that a threat? Maybe it is, maybe it isn't, but it's certainly harassment, and that's a federal criminal offense, in my understanding of the statute, already.
Okay, for questions, I will invite but not require you to identify yourself.
Thank you. I'm Don McGann. I'm at the Federal Election Commission. I'm happy to say who I am, and I did not look at the database to see who makes contributions to candidates before I voted, and in theory, I can do so much easier than most people. Question I have, given the recent disclosure mania that has swept the editorial pages in some parts of the Congress, is a question that gets lost and will probably emerge as time goes on. Judge Randolph has alluded to it. With the notion of a harassing phone call could be criminal. It begs the question of what is harassing. Given that the courts have said disclosure seems to be at a less standard, does that then allow more vague standards for disclosure? One may be happy to disclose if one knows the law is clear on disclosure, but given the fact that both the federal and state governments employ a number of vague tests as to what is a political expenditure what is one's major purpose? Is that an issue that does it change the standard merely because it's disclosure, or does the legion of cases that say you need clear lines still hold today? Probably Professor Smith is the best to start this one, since he was involved in the Speech Now case, which of course assumed that the disclosure thresholds were met, but the next case may not. So how does this play out in the future?
Well, I think one of the things that's often forgotten is that the express advocacy, issue advocacy distinction of Buckley v. Vallejo actually came about in the disclosure portion, really, of that case. At least that's where it first had its real bite, because the court on the expenditure side said, we're going to narrow the definition of expenditure to express advocacy, but in the end it doesn't really matter because we're going to say you can't limit expenditures either way. So it was on the disclosure side that the distinction first had bite, that if you were doing issue advocacy, you did not have to disclose. If you were doing express advocacy, then you did have to disclose. And I do think there's reason to worry about vagueness there as well. I mean, presumably everything every one of us is doing here might in some vague way impact the federal race. We're all sitting here talking about politics and stuff. You know, the press knows we're all a bunch of right-wing Republican shills, really, despite the official nonpartisan view of the Federalist Society. That finally woke Gene Mayer up here. You know, so I do think that issue matters. To me, in finding that line, I really think the question, and that has to be, where this has to go is the question really is, who has the burden of proof ultimately in determining whether disclosure is good? I mean, ultimately, my position is not very different from Lloyd's in terms of what I would allow, but we've set this, what strikes me as an extremely high bar in requiring those who would seek anonymity to prove that they're going to be harassed, and not just mild harassment like having their business destroyed by a boycott. You know, we don't care about that. We want serious harassment like physical bodily harm, and hey, even then, well, we got laws against that, so, you know, after the fact, the violator can always be prosecuted, no big deal, right? Shouldn't the burden, we're talking a fundamental right here again, First Amendment speech, and it has struck me that the burden really needs to be on the government, that it has a compelling interest in requiring the production of this information. And I think, given the very, you know, sort of mixed arguments that would even go to the question of the voter queues, and that's really the only argument that's much been presented here, I'm just not sure that burden of proof has even been close to being met. And to me, that's the discouraging thing I'm seeing from the courts ultimately, is not that they're ultimately in some cases ruling that things need to be disclosed or that we need to pierce that first veil of disclosure, but I don't think they've thought much about the levels. You know, to me, it's important that if you're a gay man, you don't necessarily want people to know that you gave to the log cabin Republicans. It's important to me that if you're a Republican in a Democratic law firm trying to make partner, you don't necessarily need to have your partners know that you're giving money to Republican causes. For the same reasons that some people choose not to put bumper stickers on the car, they choose not to reveal who they give money to, and I don't know why the government should require them to reveal that any more than the government would require them to put bumper stickers on their car. Why couldn't the government go around and say, we need to know who you support so your neighbors can judge, so if you support this issue, we want you to put a bumper sticker on your car under the penalty of perjury if you lie. I mean, I think the government's got to make a case, and I don't think that's been made, and that's what discourages me. Vagueness has got to be, that vagueness issue has got to be part of the answer to that as well.
Why don't we hear the next question?
My name is Jim Huffman. I'm on the faculty at Lewis and Clark Law School, and I want to raise a different perspective on retaliation and the effect of disclosure. I was, in the last election, the Republican candidate for Senate from the state of Oregon, and one of the things I learned, and my evidence is clearly anecdotal, but dozens of examples of this, is that when I would call for money, and they're probably all rank and file donors at the federal level because of the ceiling, frequently I was told that, well, I support you, I like what you stand for, but I don't want to be exposed to the incumbent. I think disclosure works very powerfully in favor of incumbents by discouraging donations to challengers, particularly challengers who are thought to be unlikely to win. And it was not just some were very concrete examples of people with pending FCC applications, people with pending land transfer opportunities with the federal government, and also people who had gotten direct calls from the senator's office suggesting it would be a good idea not to support the campaign. So I think that's an aspect of this that I haven't heard anybody talk about, and I'd be interested in your comments about that.
Lloyd, do you want to take that?
Yeah, I think that's a very important point, and that's an aspect of retaliation that we mentioned briefly in terms of the K-Street project, and in fact, and there have been similar efforts on the Democratic side of the aisle, systematic efforts to prevent people from, let's say, being lobbyists or getting, being heard on the Hill if they have a record of donating to the other party. But I think that the point you made is also a key one, and there are some examples in the paper that I submitted as part of this panel, which is there are numerous examples of people saying, I don't want to give to you because if you don't win, I'm going to be a marked man or woman, or my company is going to be a marked business, and the incumbent attorney general, county attorney, whoever, is known to retaliate against people, and that's something which, again, I think this hasn't been something it's anecdotal. It hasn't been documented. It hasn't proved to the court as much that this occurs, and some of it might be frankly illegal, interfering with the reward of contracts or whatever directly, but people do have that perception, and actually that goes to something we sort of implicit here, which is the retaliation doesn't have to actually happen. It can be simply chilling of speech. The retaliation can occur because you think if I give and my name is out there, I will be retaliated against by the official, even though that actually doesn't happen. It may even be illegal for it to happen. Or I think that my neighbors are what is like me, my boss is going to fire me, or I'm not going to make partner at my firm, I'm not going to make tenure at my law firm, at my law school, whatever the concern is. And it may not be true, but that's enough to stop you from doing it, which again is why I think that the rank and file donor, the lower level donor, where you really I have trouble seeing a real government interest in having that information disclosed, really probably shouldn't be disclosed.
I'm sorry, Lloyd. It just to add quickly, one other element to that, which Professor Huffman didn't mention, but it can also affect the ability, particularly if people want to run as like third-party candidates or challenge an established insider, so to speak, to gain consultants and the staff that they need, the kind of people who will help them with polling and fundraising. So it doesn't just go to donors, but some of those folks will sometimes feel like this is what I do for a livelihood, and if I go out and help, say, the Libertarian candidate who's going to be perceived as pulling votes from the Republican and he loses, they're going to hate me. They're going to grill me for it.
Sorry. I'm Dorpana Sheth from the Institute for Justice. I had a question regarding ballot issue context and disclosure in the ballot issue arena. Can we at least get maybe some consensus that in the context of ballot issue campaigns, the asserted rationales for disclosure that were listed in Buckley, so first to help detect campaign violations or contribution limits, and secondly, the quid pro quo corruption rationale, and thirdly, the informational interests, or what Professor Reidenberg addressed as accountability or transparency interests, do not apply in the context of ballot issue campaigns?
I would agree on the first two interests. The informational interest, I think, is harder because actually Michael Kang and Elizabeth Garrett have both written articles in this area and said one big problem with ballot initiatives is it's really hard for voters to figure out what these things are about. And unlike candidates, you're missing one big cue voters use, which is Republican or Democrat. And so I will tell you, when I was a college student in California and I got that ballot initiative book, I turned first to the statements in support against and looked to see who signed them. And that's how I decided how to vote. And these days, because of the creation of front groups with innocuous names, if you don't have information about who's supporting those groups, you may end up with 2 or 3, and people in direct initiative states have admitted this, 2 or 3 or 4 initiatives on the same topic, which are really hard to figure out what they're standing for. And it helps to know who's paying for one side or the other. Take a smoking campaign. Is the tobacco industry on one side or the other? That would tell you something probably about the campaign. So I would disagree on the informational point. I wouldn't concede that one.
Professor Smith, what do you think about the distinction between ballot and
Well, I think,
elections?
the main argument that we hear on both candidates and non-candidates is that informational interest, and I agree with Lloyd that arguably that is still very much in play on the ballot initiatives. The thing that gets me about it, again, is to a large extent the real debate here is over that secondary level of disclosure, and what I always kind of chuckled throughout this year's campaign, because every time I'd see a news report talking about some group being a shadowy group, we were immediately told who was behind the group and what their effort was, you know. This group is being run by Ed Gillespie and Karl Rove to elect Republicans, and I'm like, okay, any longer for the informational basis, do I need to know who's behind the group? I know it's got, in other words, some people are willing to put their names out there. They put their names on the papers of incorporation, they speak to the press, they put their name on the website, that there's enough information for voters to get that cue, often without requiring that we also then go after the information of who is their financial supporters, who are the people who don't want to be out front of the group.
Yeah, I don't see much distinction between the ballot initiative and the candidate elections. I mean, just an anecdote from personal experience. I ran for office in my community, did get elected, and I had to obtain a certain number of signatures on my petition. I needed to disclose who who made contributions, if any, to the campaign, and I think and this was all public information, of course, and I think the reason for that is very similar to the ballot initiative. It's the transparency of the government process, the election process, that I think the rest of the community has a right to be able to check to be sure that our local county officials are doing their job properly.
Hi, Eugene Volokh from UCLA. So there are lots of situations where people are reluctant to exercise their First Amendment rights, and not just rights to contribute, rights to speak. So for example, if I have some interesting information I want to pass along to a reporter, I might be reluctant to reveal that information to him and then have him publicize it to the public if my identity would be disclosed. If I'm being asked to write a tenure letter, I might be reluctant to write that letter if I know that it's going to be discovered in a, say, anti-discrimination lawsuit. Likewise, people may be reluctant to write things in email for fear it's going to be discovered in some lawsuit against the company or against them or whatever else. When such claims have been brought to the court has rejected them. And at times it's been actually the conservatives who have taken the lead in rejecting those, saying there's no exemption from the subpoena power for the press, but also more broadly for speakers. In the tenure letter context, it was unanimously rejected by the court. Now, that may be right, but to the extent that's so, doesn't it suggest that the legal system is really quite open to discovering information for, it's true, it's on a case-by-case basis rather than in a bulk basis, but there it's in the interest of various government interests that may in fact predictably, routinely deter a great deal of speech. But the answer is, well, that's the price we pay for having more information. Why wouldn't the same thing apply here?
No, you're wrong. No, I think the difference is all of the examples you've given are, as I noted in my opening comments, relate to legal enforcement or legal disputes where there's a particular reason. None of those require, for example, that all tenure letters up front must be signed and made public. It's in the context of a civil lawsuit where a person can discover that information. And I think that is a very substantial difference, not only because most of us don't presume that the corporation is going to engage in wrongdoing or whatever, but it goes to that burden of proof that I was talking about. I mean, the government can say, look, if there are allegations that a campaign has violated the law and we need to look at its records to demonstrate that, that may meet the compelling interest standard. But I don't know that we've shown that it's a general matter just requiring everybody to sign their names publicly to everything they do, or at least in the political realm, meets that burden on the government. Much of this really is a question of where the burden ought to go, and I think the government has in many of these cases not met a compelling interest in showing that need for an upfront, mandatory disclosure in advance. And I think that sometimes the courts recognize that, like in McIntyre, and they recognize it more often in non-areas. They don't go in and say, yes, you have to report to the village manager that you're going to be soliciting door to door, so if you violate the law, then later we'll already know who it is. They don't say if you're going to organize the union, you have to identify yourself in advance, so if you break the law later, we'll know who to get. It's always, you've come in on the backside, and I think that's a different case.
Would you require a compelling government interest before say, the identity of a reporter's source would be revealed? Because as a First Amendment matter, the court was asked to do this, but specifically didn't. And at least the majority seemed to suggest a bare relevance standard would generally suffice.
Well, it says that, but actually I think the court is applying a compelling interest standard. That is a compelling interest in the functioning of the justice system and the ability to gain the information needed to make it function. And in the particulars there, they were at that particular point, the defendant was saying, well, you haven't shown that you absolutely have to have this particular piece of information. And I think that's a little different level of generality. I do think the general standard still is that there has to be that strong government interest.
Can I also, I think they're really, Gene, I think they're terrific examples, but I just wonder whether they're, as you know, the First Amendment is filled with the irresistible counterexample. Mm-hmm. I mean, that's basically First Amendment analysis.
Yeah.
And one of them is, for example, we protect the anonymity of jurors in certain situations. Maybe that's a compelling interest, maybe it's not. We protect the anonymity of grand jurors. When, in the olden times, when people went to a video store to rent a VHS tape, Congress passed a law protecting the identity and the, as you know, what movies you were renting. And there are statutes also protecting information that you supply to motor vehicle agencies from disclosure, from them disclosing all kinds of personal information. So, I mean, the examples you give are one side, but there's a lot on the other side, too.
But those are congressional choices. It's not like there's a constitutional entitlement to those kinds of rules.
Or judicial choices.
Yeah, fair enough.
Yeah.
Thank you.
Hi, my name is Peter Jaffe. This is mostly a policy question for Professor Reidenberg, but I suppose it applies to everyone. I understood you suggest that revealing the information about rank and file contributions may be useful because modern aggregation software and data mining techniques allow that information to be useful. And I've also heard a lot about accountability. But by that same standard, there are modern technology algorithms called hashes. For those who aren't aware, a hash is basically a way of redacting sensitive information but keeping the rest of a data pool useful. So a great example is law school exams. These days you don't usually write your name on an exam, you write a little code on it. That way the professor doesn't know who you are, they're unbiased, but it can still eventually go into the database under your transcript. So my question is, why can't we have our aggregation and our accountability but have our anonymity too?
Because it doesn't work. When you look at the examples, and there's been a lot of computer science research in this area, as well as some law scholars like Paul Ohm who've been writing, it's very easy to reverse engineer those hashes. So take the law school exam example that you just gave. Student has an ID number for an exam. I don't know who that student is in my exam, but it's relatively easy to find out if that ID number has taken other exams, and the other exams that they took only correspond to one student who's happened to register in those courses. So those kind of methods tend, in aggregates, to be easier to unpack than one might think. So I'm not convinced that kind, I used to be, but more recently with some of the studies that have been coming out, I'm no longer convinced that kind of aggregation enables the sort of anonymity to be able to have the transparency yet protect privacy at the same time.
Josiah Neely, Bob Colson and Bostrom. My question is about the scope of the informational interest, and I heard several of the panelists say that there's an informational interest in disclosure because voters could use that information about contributors, personal characteristics of the contributors as cues for how they might decide to vote. But there's a wide variety of information that people might like to know about supporters of candidates or ballot measures that they might, find useful in deciding how to vote. Religion of supporters, right? If a particular candidate or measure is supported by members of a certain religious group, right? Mormons in case of Proposition 8, there's a lot of talk about that. Income, educational background, sexual orientation. And so the question is, if there's an informational interest that can require compelled disclosure, can we require contributors to disclose that information as well? And if not, what's the limiting principle? How can we prevent that and still say that voter queue is a compelling interest for disclosure?
Well, I think it's a very good question, but I think there are some limiting principles you could think of. I mean, one thing is it's the usefulness of the information is the standard for how strongly the informational interest exists, and the ideas I threw out about might want to know about people giving from in-state or out-of-state or particular employment groups or whatever. Those seem to be the most, and those are the information we tend to ask for. Those seem to be the strongest informational interest. The other things, connection about people's religious beliefs or sexual orientation, actually income information we tend to have because we know where people live, right? And so we have some information there. But those seem to be much less informative for voters, and arguably, they may increase the risk of retaliation against particular identifiable groups, whether it's historically discriminated groups or groups that otherwise, congregate in a way. So I think there would be ways to draw limiting principles without sacrificing the information that you can gain when it's at the strongest level of interest.
Yeah, there's a well-known principle in information privacy law called data minimization, which is you only collect the absolute minimum amount of data necessary to accomplish the legitimate purpose of processing. And that really combats against data creep. And I think that the question about scope of information is really getting to a data creep problem, to which from a fair information practices or privacy perspective, the response would be you absolutely minimize the data that you collect in as narrow as possible. So voter queuing is too broad a category. You wouldn't really be able to come up with an appropriate range of information, I think, in many contexts, to say that we have to compel now disclosure of religion, or we have to compel disclosure of sexual orientation, because those items are going to be too far afield from a legitimate purpose to have the government having the information in the first place.
My name is Ken Klukowski, and my question is for Professor Reidenberg. Why are you distinguishing, what's your rationale for distinguishing between physical retaliation versus economic retaliation? Not all physical retaliation is created equal. If someone says, if you do this or you support this, I'll kill you, that's one thing. But if someone were to say, if you support this, I'm going to spit on you, versus if you support this, I'm going to fire you and you're going to lose your livelihood. I'd say in an event like that the chilling effect of the economic retaliation would be far more significant. And it seems that from a free speech perspective, setting aside tort law, criminal law, all sorts of other areas of law, from a pure free speech doctrinal standpoint, isn't the issue with retaliation that it has a chilling effect on speech? So shouldn't that be the metric? That seemed to be, when I was taught free speech, and I thought I was taught well because my professor was the gentleman sitting to your left, the chilling effect on speech was a consistent theme that we saw throughout the case law.
Sure, let me come. I guess it's really how are we defining harassment? What level? Earlier when I was talking about it was in the context of harassment. So in each of the examples you gave, I wouldn't have any problem saying those are wrongful acts. So the physical attack, the physical threat, maybe I'm going to spit on you might not be quite high enough for us to say that would be a misdemeanor type level. The firing, terminating someone, well, that's wrongful termination. I would be perfectly willing to say, if I am a school teacher, for example, and I'm now terminated because I made a campaign contribution, that is an illegitimate thing. It's a wrongful termination. On the other hand, to say that it is a wrongful act for an individual to decide they won't buy from someone because of political opinions that individual has. I'm not so willing to go that far. I think it's really, how far are we going to go in drawing a line, making a distinction between what is the wrongful act that we are going to say is a discriminatory type act that we sanction. In terms of the chilling effect, I guess I would put it there. I mean, lots of things can be read to have chilling effects. It doesn't mean that all of them are ones that we're going to say are of a level that the First Amendment ought to be protecting against it. So I would I would say it's really, what are the things that we say are unlawful harassment, and I'd limit it there.
But Joel, if I may, let me ask a question. In most states, it's not illegal to fire somebody for their political orientation. Certainly not private employees. I don't know if there's any state where it's illegal to fire some private employee for political orientation. Would you be suggesting that the mandatory disclosure as a constitutionally permissive statute of government hinges on some right to protection there from discharge?
Well, if there isn't, and there are all sorts of state law cases with abusive wrongful termination, so I wouldn't, personally, I don't know whether I'm sorry? Of firing for political opinion? Okay. Where it's treated as a wrongful termination? So that sounds like it's probably a very small number compared to typical wrongful terminations. I don't know how often this comes up. But if we're not willing to say as a matter of contract law that's a problem, I guess my take is push it there toward contract law. I'd want to see it in that dimension. We evolve our notions of what wrongful termination, abusive firings are. In certain areas, you can't fire a public employee because of their political beliefs. Private employers, different story.
Judge Randolph, I wanted to follow up on something that was raised earlier by, I think, Jim Huffman, which is, suppose it turns out that disclosure requirements are shown to really help incumbents, as he pointed out, and it's shown that disclosure requirements are enacted or motivated by the desire to protect incumbents, to help stamp out challengers from getting off the ground with anonymous donations because the donor's scared about what will happen to the contract, what will happen to the land grant, what will happen to the license. Is there a way that courts can take that into account in assessing the First Amendment implications, do you think, of disclosure requirements?
Well, I don't know how you show the motivation. I don't think the motivation for the statute would make a difference. The effect would, but I find it difficult to fit that into any of the pigeonholes that I'm aware of under the First Amendment. I just don't know that. I think it's a very difficult question. I don't know the answer.
Next question.
I'm Andy Klausner from the Individual Rights Foundation and Reason Foundation. I'd like to follow up the issue of disclosure, confidentiality, and risks or threatened harm or anticipated harm in the controversial initiative ballot proposition context. Looking back at the Ward Connerly experiences that he's had, I've worked with Ward in his American Civil Rights Institute in various states where contributors, there's one of the more active opponents of the what we call the Civil Rights Initiative that would ban racial preferences and sex preferences in government, hiring, education, and contracting. One of the very outspoken groups that opposes these initiatives is a group called BAM, which stands for By Any Means Necessary. And they are extremely aggressive and take pride in finding the names of people who contributed in favor of the campaign and do what they can to make them regret coming close to giving any money by boycotting, by protesting in very open ways that it seems to me not only chill the exercise of free choice and free speech to support a political cause that you believe in, but it's rather, it adds a lot of acrimony and disharmony to elections in ways that I don't really see a compelling or a weighty interest for. So I'd just like to ask if there's anyone who wanted to comment on that type of specific case. It's sort of analogous to the Prop 8 case in California, where the manager of El Coyote restaurant in Los Angeles, who gave $100 to the campaign for Prop 8, which was to prevent gay marriage, to roll back the California Supreme Court decision on gay marriage. I'm sure everybody here is familiar with it. But she was harassed and hounded out, forced to resign, as other people. She lost her job because of it for a $100 contribution. Hard to see it seems to me, for a minimal contribution, any compelling information that is produced by the required disclosure. We see in reality where there were websites, and somebody alluded to in a prior question, there were websites that said we're going to target everybody that gave, and we're going to get them and make them regret it. So where does that come out for those that favor civil discourse, say, here?
Well, I'll grab the mic here and hog it for a bit. It's one of the things that I think is very important to recognize, I guess I just say, is that disclosure leads to much higher privacy costs now than it did just 20 years ago. 30, 40 years or 35 years ago when the Supreme Court decided Buckley, if you wanted to get the information, somebody had to go down to the FEC and manually look through reports and so on. Nowadays, this is all put up, as they say, instantly on the internet, where everybody can get to it and can look it up in no time at all. And that makes it much easier. And then you have groups like Huffington Post and sites called 8 Maps and so on that now put on the internet so that you call up the campaign contributor, and not only do you get the information, but immediately springs up a map to the person's home. What his possible purpose is there for putting a map, a street map, showing you how to get to the person's home? So the cost of this have gotten much higher. The other element I'll add to this is just the Socialist Workers' Party was mentioned their exemption. So I was at the FEC still the last time we approved that exemption, and the kinds of things they cited as harassment are nothing more, by the way, than are documented from Proposition 8 or from Doe v. Reed. I do have some different thoughts about Doe v. Reed because I think Joel makes a good point that it's kind of an official action that people are taking, a government action. But it brings back that question again of who's going to have the burden of proof, and are we really going to say, well, okay, yeah, you can be anonymous, but only if you cross this really high threshold of showing not just inconvenience, not just being bothered, not just that you don't want people to know because other people will come and bug you for contributions too, but harassment, and really high level of harassment, again, that we're told in some cases has to go to the level of sort of, threatening your livelihood or threatening you with, serious physical harm. And I just go back to that question, it strikes me that the courts have not held the government to its burden of proof on these questions.
All right, let's go with the last question because we're... Oh, go ahead.
I was just going to jump in and suggest that, there is a model out there that Judge Randolph had alluded to, the Driver's Privacy Protection Act. Because what that statute does is, while the information that one has to provide to get the driver's license is quite detailed, the statute limits the purposes for which that information can be used by those who obtain it from the government under the sort of FOIA equivalent of the Driver's Privacy Protection Act. And in a sense, what you have is the statute defining a set of permissible purposes, which are the ones that are the compelling reasons that the government has for collecting that data. And other uses are defined essentially as secondary uses and can't be processed for those secondary uses without the driver's consent.
But if I can say, I just don't think that's realistic. People don't care who gets a driver's license. Once you release the information on, political contributions, it's out there, and it doesn't matter that the person who released it only uses it for the right reason. Everybody else has it and can use it for whatever reason they want.
And some of the kinds of harassment, economic boycotts, picketing, and so forth, those are themselves First Amendment protected. You may not be able to prohibit that kind of secondary use.
But come back, that comes back to the technological question that was asked before. There are ways to put information on the net that are protective of access controls. I mean, if you're using Lexis, for example, and you want to go into the assets database, you have to represent that you're not using it for consumer reporting purposes, because Lexis doesn't want to be a consumer reporting agency. There are devices that can be used that push if someone is acquiring the information and it's traceable on the net, where someone acquired the information. If they're using it in ways, or doing the mashup, mapping where the house is, that's far enough afield from why that data was public online, that can readily be a sanctionable offense.
Okay, last question.
I'm Arthur Hellman, focusing on the federal election campaign Finance Act reporting requirements. When you make a contribution, they tell you we're required to get the name and occupation of anybody who contributes $250 or more. I wonder if part of the problem is a very low level at which these reporting requirements kick in, and whether a lot of the problems could be solved by setting different levels and keeping them up with inflation so that modest contributors can contribute without any fear of retaliation.
Professor Smith, what do you think?
I mean, I absolutely agree, although, you know, in my own view, there's probably, given the contribution limit, for example, an individual contribution limit to campaigns of $2,400, I'd probably say, therefore, there should be no disclosure of any contributor to a campaign, because nobody's giving more than $2,400, and nobody's therefore that influential that the public doesn't get any big cues from it. Other than knowing that. But certainly it's something, it has never been adjusted for inflation. That alone would bring the current federal level up to $700 or so. Some states have levels as low as like $10, and we just don't need to know that information. So it is true that, like many, many problems, the magnitude of the problem could be lessened if there was just a little more reasonable judgment made at the statutory level.
Oh. Okay, that's the last word. Thank you to the panelists, a great panel.